approximately where it is on the docket?
It was about 2/3 down the way when I found it. I'm sorry?
Last name is?
Germain.
Germain.
I'll tell you the page. My apologies to the court and to staff. Page 27, Your Honor,
Way back.
at the very top.
27, so it's at the
Apologize, I should have had that for you.
Eugene Germain.
Yes, ma'am.
It's not that far, right?
Okay. Where is he? Do we know where Mr. Germain is?
Should be in the main jail.
Is that
There he
Mr.
is.
Germain?
He is in the main jail.
Yes, that's him.
Can you hear us, Mr. Germain? Can you hear us?
Yes, I'm good. Yeah.
Can you see your attorney?
Yeah.
Okay. I don't want you to say anything because your attorney's here. He's going to speak on your behalf, okay? With regard to probable cause, do you have any argument as to that?
Yesterday was a self-surrender. I actually met with the detective when we surrendered him at Fort Lauderdale Police Department. I reviewed the PC yesterday. I don't have an objection. The detective basically told me his hands were tied, that there was just enough probable cause to make an arrest, so he arrested him, so we won't be objecting on the ground that there's no probable cause.
Okay, so I will find probable cause. I'll hear from you with regard to bond.
Sure, Judge. Mr. Germain is a resident and is, first of all, is a citizen of the United States. He's a resident of Fort Lauderdale. He's a landlord, and the victim is a friend of one of his tenants. With respect, he went over to do a landlord-tenant type issue with a complaint. That escalated into an argument to where it's our position that Mr. Germain was struck first, and then he acted in self-defense. He has significant ties to the community, his wife, his family. He is a property owner. He's not going anywhere. This is a self-surrender. During the course of the investigation, when I spoke with Detective Benson, Mr. Germain maintained contact with Detective Benson once I became involved. I had significant contact with Detective Benson, and then upon request, we surrendered yesterday. So we're going to be asking, in light of those circumstances, to set a bond at $1,000. I don't believe there's any criminal history for Mr. Germain, and there's never been an incident involving this alleged victim until...
Do you have any criminal history?
No, Judge.
Who are you?
No?
Nicole Pete on behalf of the state. No
morning.
criminal history, Judge.
Okay.
And this comes from April 5th, and there's been nothing else
Right.
in the interim between April 5th and...
Do you have any reason to have any contact with this person?
Other than that, again, Mr. Germain is the landlord to the victim's girlfriend or friend. So if he needs to come over and do something at that particular location and he's there...
Is he the landlord for 8421 Lagos de Campo Boulevard in Tamarack?
That I don't know the property location. I believe that he's the landlord at there. I don't know if that's the victim's address or...
It is listed as the victim's address, so I'm trying to see if
I'd have to ask Mr. Germain. If I would have no problem if he states the address where he's the landlord at.
Mr. Germain, your attorney says you may answer the following question. Do you own the property or supervise the property at 8421 Lagos de Campo Boulevard in Tamarack?
No,
No.
the victim address.
Okay, so you don't have any reason to be at that address?
No.
And no reason to have any contact with her? Okay.
And I was just going to ask for no contact. Man, if he doesn't want him at the, because I guess he's not a tenant, he can obviously have law enforcement come trespass warning, whatever, to prevent him from.
The problem with that is the tenant can invite...
But
Okay.
not if law
That's the
enforcement
issue.
trespass.
Well, Mr. Germain, I'm going to set your bond in the amount of $1,000. As a condition of your bond, I'm going to direct that you have no contact with Gabrielle Anthony Garcia. If for any reason you're in a location where you think she might be or need to be, you just need to leave there and come back another time. You understand?
Yes.
Okay. Good luck to you, sir.
Thank you, Judge.
Okay.
Thank you, State. Have a great day.
Sure. Which case? And where is it on the docket? Page 2. Philomene Francois. Where's...
Ms. Francois? She declined the services of the public defender, Judge?
Well, the public defender here in the courtroom asked me to call it out of turn. Okay. Okay, come on up, sir. Good morning. Could you just state your full name for us loud enough so we can get it on the record?
Ronel Santelfis
Okay. And your relationship to Miss Francois,
is my girlfriend.
your girlfriend?
Yes.
Is that her baby?
Yes, then that's correct.
Yes?
Yes.
Okay. Just so the record's clear, you're listed as the alleged victim in this case. I do find probable cause, and Ms. Francois, I don't want you to say anything about the facts of your case. Can you see that Mr. Sentinel is here in the courtroom?
Yes.
Okay. What would you like to tell me, sir?
That was like a little misunderstood. So I was calling the cop, so because we got a little argument about over a car. That's it. And she getting mad. That's it. And I was calling the cop so they can slow her down because I don't want to press no charge and anything. So like she's not a dangerous person. She's a good person.
Okay. State, do you have any prior history on her?
No, Judge.
Okay. Any recommendation as to bond or contact?
Judge, the state would ask for a $5,000 bond, no victim contact.
Okay. I'm going to set, I do find probable cause. I'm going to set her bond in the amount of $1,000 on this case. I'm going to direct, and on count 2, I'm going to ROR her. I'm going to direct that Ms. Francois, that you have no harmful contact with Mr. Sentinel. Do you understand?
Yes.
You know what that means?
Yes.
Okay, so your bond is set at $1,000 on count 1 and ROR on count 2. No harmful contact. I'm not going to prohibit you from seeing him because I see there's a young baby, and I think he's indicated you two want to work this out and talk to each other. So I'm going to order no harmful contact between the two of you. You understand?
Yep.
Okay. Thank you, sir, for coming.
Thank you.
Okay, anybody else need to be called out of turn? Anybody else here on another case? Yes, ma'am? Okay, so you just let me know when the attorney's here. Okay, so we have Shakitra Nicole Burgess.
Ms. Burgess, is your presence, Judge?
Good morning, Ms. Burgess.
Morning.
You're charged with touch, strike, battery, domestic violence. I do find probable cause in your case. State any history?
Yes, Judge, a 2014 driving with license suspended.
I can't hear.
A 2014 driving with license suspended and a 2011 no valid driver's license.
Okay. Defense?
Judge, in speaking with Ms. Burgess, she's been residing in our community her whole life. She is 28 years old. She's currently working. She works at a clothing store. She's a cashier. She makes approximately $8.50 an hour. She is a single mother. She has 2 children, ages 8 and 6. My understanding is the alleged victim is her ex-boyfriend. He left the premises yesterday, so he's no longer at the residence. Judge, considering her strong ties to community, her lack of, right now, significant financial resources, considering she only gets paid minimum wage, a mother of 2 children who rely on her for their sole financial well-being. Judge, we'd be asking you to consider at this time placing Ms. Burgess on standard pretrial.
Is the address at Pembroke Road, Apartment 7, is that her residence or his?
It's mine, ma'am.
Okay. Did pretrial interview her?
Yes, Your Honor. We
Yes.
interview her, but we do not make recommendations on persons charged with domestic violence.
Right. Okay. Ms. Burgess, I'm going to set your bond in the amount of $1,000. As a condition of your bond, you are to have no contact whatsoever with Christopher Cobb. You understand?
Yes, ma'am.
Okay.
Judge, and I'm assuming you're denying our request as far as standard pretrial?
Yes, I'm going to set a $1,000 bond.
Yes, Judge. Thank you.
Denise Asenio Ramirez.
7447.
Judge, we're going to require a Spanish interpreter for Ms. Asensio.
Okay, could you call for a Spanish interpreter, please?
Thank you. Toma asiento, por favor.
Sir? Could you call for a Spanish interpreter, please? I put it on recall. LaShawn Sotolongo.
Ms. Sotolongo? She's here present, Judge?
Ms. Sotolongo is charged with aggravated battery with a deadly weapon, domestic violence, touch or strike battery, domestic violence, and a capias on a misdemeanor case. I do find probable cause as to each of those charges. On count 3, the capias, the misdemeanor capias, there's a $500 bond that was already set. State, you have anything on priors?
Judge, 2012 no valid, 2011 no valid, 2010 no valid, and another 2010 no valid.
Defense?
Judge, is Ms. Sotolongo, she's been residing here her whole life. She's 31 years old. At this time, she's not working. She's presently collects disability. She suffers some from like depression and stuff like that. She gets from disability about $725 monthly. The alleged victim and her is her ex-boyfriend. They were dating. He does not live with her. They live separate and apart. She lives in Fort Lauderdale. Her monthly rent is $450 a month. She lives there with her 2 children, ages 8 and 9. Judge, considering her lack of any serious history, no prior violent offenses, and considering her financial resources, we ask you to consider a $1,000 bond on count 1, $500 bond on count 2, which with count 3 combined would be a total of $2,000 bond on her behalf.
Okay, I do find probable cause as to aggravated battery with a deadly weapon, domestic violence, and as to touch or strike battery, domestic violence. Has anyone had contact with this victim? He's a minor. No contact? Based on the allegations in the probable cause affidavit, I'm going to set bond on count 1 in the amount of $10,000. On count 2, I'm going to set bond in the amount of $1,000. Ms. Sotolongo, if she is able to make bond on this case or post the bond, she is to have no contact whatsoever with Elroy Bulgin. Do you understand that?
Yes.
Good luck, ma'am.
Caridad Leon.
She's here present, Judge, at Maine.
Judge, I have a probable cause argument.
Okay, I'll hear from you.
Judge, I didn't see an age.
I need you to speak up, please.
I didn't see an age as to the victim.
Okay. State.
One moment now. That's fine, but Your Honor, if you have one moment. What is he having pre-trial? Your Honor, the state's gonna be requesting 24 hours. I believe, so I think pre-trial has some information, but there is probable cause for battery.
There is probable cause for battery. I agree with the defense argument. There's no probable cause as to the age, and I give the state 24 hours to perfect that.
If there's probable cause for battery, the defendant is currently being supervised in case 17-4662-MN10A for prostitution. She was placed on pretrial supervision on the 20th of May, and we ask that based on that finding of probable cause that her pretrial status be revoked at this time.
Okay, I'm going to grant that request. I am finding probable cause as to battery on this case. and giving the state 24 hours to perfect with regard to the age of the person, the alleged victim in this case. Reset it for tomorrow.
Judge, the only thing, the offense at this time, I understand as far as the offense that's here before you, you're giving 24 hours to perfect. The one open case which she's currently out, I believe, on pretrial, you revoked pretrial. The only thing I wish to inquire is if that particular case is filed or not filed yet.
I don't know, she is on pretrial on that case.
Right, the reason why I want to bring up the point if it's filed or not filed, if it's not filed, considering I believe it's a misdemeanor offense, I understand you're on a revoked pretrial, would you impose a monetary bond on that case?
It's only been about 2 weeks since her arrest, so we're not.
No, I'm revoking on case number 170046662 MM10A, I'm revoking her pretrial status. So the state's going to, oh, you did an order. Okay.
Right, and now what I'm asking is if you would then consider putting a monetary bond on that case.
I am not.
Oh.
Thank you. Okay. Okay, so I reset for you to perfect on the other until tomorrow at 8:30. Make sure I did that right with you. Yes? Okay, thanks. Franklin Roosevelt Jones. Mr. Jones. Is that you, sir?
Yes, me.
Okay, you're here today on a violation of probation on a misdemeanor case. You're being held no bond. I find probable cause. Judge, you need to see Judge McHugh. Looks like you're going to see Judge McHugh. I don't know. It doesn't have the date, but as soon as they can set you, okay?
Okay, thank you.
All right. Mario Leon Elizondo. Is that in the main jail?
I've been informed he's at North Broward, Judge.
Thank you. Mario Leon Elizondo. North Broward, are you there?
North Broward, we're here. We showed on our sheet that it was the main jail, so we got to look him up to see where he's at.
Okay. Thank you. The main jail. They're saying he's at the main jail.
Judge, I've been informed. What I'm being informed, Judge, if he's not there currently, he must be en route. He was transported to North Broward.
Okay, so we'll put it on recall.
Okay.
To Gray Linton Wilby.
Mr. Wilby is here present at Maine. Come on up, Mr. Wilby. He declined to serve the public defense.
Mr. Wilby, his case is going to be reset for tomorrow morning. I'm recusing myself on that case. So we set that for tomorrow morning at 8:30, please. Oswald Oscar Roll.
Mr. Rolls here present, Judge?
Mr. Roll's charged with one count of touch or strike battery domestic violence. I do find probable cause. They've only alleged one count, it looks like. Although there's two listed victims on the probable cause affidavit, only one count is alleged. I do find probable cause as to that count. State, do you have any priors?
No priors, Judge.
Defense?
Judge, I speak Mr. Roll. He's 49 years old. He's currently employed. He works at Quick Cuts. He's a carpenter. He's been working for the same company now for about 2 years, making approximately $18 an hour. He will be living separate and apart from the alleged victim. He has other family members who reside in Fort Lauderdale, so he'll have no contact with the victim. My understanding, Judge, this is his first contact with the criminal justice system. He is a registered voter. Considering this is a misdemeanor offense, he has no priors. I'd ask you to consider a $1,000 bond on Mr. Roll's behalf.
Okay, I do find probable cause. I'm going to set bond in the amount of $1,000. I am going to order as a condition of his bond that he have no contact with Del Rita Russell or for Alicia Roll, either of them. Understand that, Mr. Roll?
Yes, I do.
Okay.
Good luck, sir.
Mario Deshawn Boone.
Mr. Boone is here present, Judge at Maine.
Mr. Boone is charged with 1 count of battery on a person 65 years of age or older. I do find probable cause. State, any priors?
No priors, Judge.
Defense.
Judge, Mr. Boone is 19 years old.
Only 19 years old.
Yeah.
He's actually right now.
He does?
Looking for
Hang on, sorry, they're talking to me here too. Sorry?
I show 9 prior arrests. He's just 19. And he does have some juvenile priors.
Okay, thank you. Did you hear that?
No, we can, I didn't hear.
Okay, so I asked if there was any priors. They said he's 19 years old. There are priors, but they're juvenile arrests. There's nine of them.
Yes, Judge. And let me continue. He's right now looking for employment. He was working a month ago at Strike 10 Bowling Alley as a dishwasher, making about $10 an hour. The person that he was relying that worked with him, that would take him to and from his job, unfortunately, he quit his job, which forced him to quit that job because he no longer had a ride. So right now he has no financial income coming in. He has no money in the bank, no property. He will be living separate apart from the alleged victim. He's going to go down to Miami and live with his mother. Judge, considering his lack of financial resources and the fact that he's been living here his whole life, we'd be asking you to consider a $1,000 bond on Mr. Boone's behalf.
Has anyone had any contact with the alleged victim in this case? His grandmother? No? Okay, I do find probable cause. I'm going to set bond in the amount of $5,000. I'm going to order as a condition of his bond that he have no contact whatsoever with Sarah Mae Weaver. You understand that, sir?
Yes.
No contact at all. Stephanie Beasley.
Judge, I would ask,
Beasley is approaching here at Maine.
Judge, I would ask if the court could place this case on a brief recall. The only issue is, my issue is, there's several other cases, punishable with life offenses that Judge Cohen signed a warrant for. I had a computer malfunction, so I just want to read the PC to determine whether or not I want to make an argument as to proof,
Okay.
evidence, presumption, great.
It's actually printed supplemental reports on all 3 of the separate cases. If I could provide them to you.
I have them here.
Well, you have the PCs. I think the supplemental reports have a little bit more detail.
Okay.
A little bit better written, so that's why I wanted.
Okay, so we'll put it on recall.
Thank you, Judge.
Thank you, Judge. Have a seat. We're placing a case on recall. The attorney in there needs time to read all the reports.
Eric David Robinson.
Mr. Robinson is here present, Maine Judge. You can find the service of public defense.
Mr. Robinson is charged with domestic battery by strangulation in a dating relationship. He's also charged with touch or strike battery. I do find probable cause. State, do you have anything with regard to Mr. Robinson?
Judge, he does have a 2016 case that was declined. It was not filed by our office, but it is the same victim. It was an aggravated battery with a deadly weapon.
Okay, I do find probable cause as to count 1. I'm going to set bond in the amount of $10,000. On count 2, I'm going to set bond in the amount of $5,000. I'm going to order as a condition of any bond posted that you not have any contact whatsoever, sir, with Isabella Tagliarini. You understand?
Yes.
Thank you. Charles Fishbane. Mr. Fishbane's charged with battery on a person 65 years of age or older. I do find probable cause. State.
No priors in Broward, Judge.
Defense.
Judge, in speaking with Mr. Fishbane, as the state confirmed, this is his first arrest. He is a registered voter here in Broward County. He's been residing in South Florida his whole life. He's 44 years old. He is self-employed. He has his own company. He works for, it's type of a recruiting service. He works with hundreds of kids throughout Dade and Broward and Palm Beach. He's been doing that for the past 15 years, helping high school kids trying to further their abilities with the type of sport they choose. Roughly, he makes about $2,000 a month doing that. The alleged victim in this case is his father. My understanding is his father did move out yesterday, but he does realize that he will have to be separate and apart. So if the father is still there, which we do not believe he is, he'll make other sort of arrangements. But he knows to honor your court order as far as having no contact. He does. He lives at his place in Hollywood with his wife. They've been married for 15 years now. They have one child. He's 7 years old. His wife is a stay-at-home mother. Judge, considering his very strong ties to the community, this being his only offense ever in his life, we'd be asking you to consider a $2,500 bond on Mr. Fishbane's behalf.
Mr. Fishbane live in Hollywood?
Yes, he does.
And does his father live at that same address?
My understanding is the dad moved out yesterday, but he does understand if the dad is there for whatever reason, he's supposed to have no contact.
State, you have a recommendation with regard to bond on this?
State would request a $3,500 bond, Judge.
Okay. Mr. Fishbane, I do find probable cause as to this offense. I am going to set bond in the amount of $2,500. I'm going to order as a condition of that bond that you have absolutely no contact with Lawrence J. Fishbane until further order of a court, whether it's me or some other judge that allows you to have contact. You understand?
Yes.
No contact means indirect or direct. That means you can't have anybody else speak to him on your behalf. You understand?
Yes.
Okay.
Judge, we also have the Spanish interpreter present.
Let's call Denise Asenio Ramirez.
Yes, Mr. Sentinel is here, President May.
Good
Your
morning.
Honor.
Could
Theodore
you,
Leal.
you raise your right hand, sir. You swear to translate from English to Spanish and Spanish to English to the best of your ability.
Yes, I do, Your Honor. Theodore Leal, L-E-A-L for the record.
Okay, we have a Spanish interpreter here in the courtroom. Miss Asenio Ramirez.
Señora Asenio Ramírez,
You are charged with touch or strike battery domestic violence.
se le acusa de tocar o golpear de violencia intrafamiliar.
You understand that?
¿Entiende eso?
Sí.
Yes.
I do find probable cause.
Determino que hay indicios de culpa.
And with regard to bond, state?
State would request $1,000 bond, Judge. I see no priors.
$1,000 de fianza está pidiendo la fiscalía.
Going to set bond in the amount of $1,000. As a condition of the bond, ma'am, I'm going to order that you have absolutely no contact with, looks like, Alan Fernandez.
Señora, se pone una multa de $1,000 y como condición de esa libertad bajo fianza no va a tener ningún contacto en absoluto con Alan Hernández.
You understand?
¿Entiende?
Entiendo.
I understand.
Okay.
Judge of the defense to be heard lawyer now?
Yes.
Va a hablar la defensa.
And speaking with Ms. Asensio, she's 40 years old. She's been living here for the past 12 years.
Hablando con ella, tiene 40 años, la señora Asensio, y tiene ya 12 años viviendo acá.
This is her first arrest ever in her life.
Es la primera vez que la arrestan en su vida.
She did become a U.S. citizen and she did register to vote.
Ella se volvió ciudadana estadounidense, está registrada para votar.
She doesn't work. She's a stay-at-home mother/wife.
Así que ella no trabaja, pero ella es ama de casa y esposa.
She has 3 children.
Tiene 3
ages
niños.
5, 17, and 20.
De 5, 17 y 20 años.
She, right now, is the only one that takes care of their 5-year-old child.
Y es la única que cuida del niño de 5 años.
Now, the alleged victim is her fiance / boyfriend.
Y la presunta víctima es el prometido o novio.
They've been together for 7 years now.
Ya llevan juntos 7 años ambos.
Judge, we'd be asking you to consider a straight R&R, considering she has no sort of financial resources. She relied on her fiance for all financial support of her and her children.
Y pedimos que le den libertad bajo palabra, porque ella no tiene medios económicos, ya que ella depende totalmente económicamente del novio para el sostén de ella y de los niños.
Now, Judge, this is going to be an unusual request, and I don't know if the court will be able to, I guess, grant my request, but I got to, and speaking with Asensio, she has nowhere else to go and live.
Como la señora Asensio no tiene ningún otro lugar para ir a vivir, le voy a hacer un pedido bastante inusual a la corte.
Considering this is her first arrest ever,
Como
she's
él,
been married for 7 years and there's no other altercations.
y ella ha tenido 7 años ya casada y la primera vez que la arrestan.
Impose a no harmful contact as opposed to no contact, because then she really has no place else to go with her and her child.
Okay,
No
I'm
tiene
going
dónde ir.
to leave the bond at $1,000, but I will change the status to no harmful contact with the victim.
Your Honor.
Voy a de los $1,000 de fianza, pero que el contacto con la víctima sea contacto, pero sin hostilidad.
Yes,
The
state.
state would object without having any information.
Well, the information I have is in the probable cause affidavit that he refused to prosecute, provide a statement, or let photographs be taken. So,
Sí, él no dejó que tomaran fotos ni hiciera declaración tampoco.
so based on that, I'm going to order no harmful contact.
Voy a pedir que sea contacto, pero que sin hostilidad. Contacto sin hostilidad.
And, Your Honor, just for the record, that will be over state's objection.
I understand. Thank you.
La fiscalía protesta, pero aún así queda así el juicio.
Could you make an announcement to see if there's anybody else that might need your services?
Yes, Your Honor.
Señor, ¿quién más
The court.
español?
Oh, he's going to do that for us.
Two gentlemen raising their hands. Judge.
Okay.
Apellido.
Este nombre. David. ¿Solamente hablas español o inglés? Okay, ¿qué nombre? David Ramirez. David Ramirez, Judge. I'm going to try and locate his page. David Ramirez Romerio? Valerio. David Ramirez Valerio.
Do you have any idea what page it's on?
31, Judge, so it's towards the end of the docket, probably second to last page.
Give me a message on the phone.
Valerio.
Delby Antonio Valerio.
Delby Antonio Valerio.
Is that it?
Yeah.
Okay. Mr. Valerio,
Señor Valerio,
you're here this morning charged with keeping a house for gambling,
está aquí esta mañana
bookmaking,
por tener una casa para apuestas.
another count of
hacer
keeping a
apuestas.
house for gambling,
Otro cargo por tener una casa para apuestas.
another count of bookmaking,
Otro cargo por manejo de apuestas.
another charge of keeping a house for gambling,
Otro cargo por tener una casa para hacer apuestas.
and another count of bookmaking.
Y otro cargo por hacer manejo de apuestas.
I do find probable cause as to each of those counts.
En cada uno de estos cargos si hallo que hay indicios de culpa.
Anybody wish to be heard?
¿Alguien quiere decir algo?
Judge, showing no priors by the state, the convenience bonds are fine.
The bonds have been set on count.
Judge, he's advising me that his cousin will post bonds, so we're fine with the standard bond.
Okay, the bond set in count 1, $500.
Son $500 el primer cargo.
Count 2, $1,000.
Dos son $1,000.
Count 3, $500.
Cargo 3, $500.
Count 4, $1,000.
Cargo 4, $1,000.
Count 5,
Cargo
$500.
5, $500.
And count 6, $1,000.
Cargo 6, $1,000.
It looks like 1, 2, 3, $4,500 total bond.
$4,500 es la fianza total.
There was one, español?
Apellido.
Jose Rafael. Let me try and find him. Do you know what page?
José Rafael.
Jose Rafael, no?
Rafael Gomez?
Rafael Gómez.
Rafael Gomez.
Is that it?
Rafael Gómez. Yes.
Yes or no, Rafael
Yes.
Gomez?
That's it.
Rafael Gómez.
Charged with a municipal ordinance violation?
Una violación a una ordenanza municipal
Trespass after warning, where there's a sign
Después
no trespassing.
de una advertencia, tuvo un acceso ilegal.
I do find probable cause.
Determinó que hay indicios de culpa.
Bond is set in the amount of $25.
La fianza es de $25.
If you'd like to resolve the case today,
¿Quiere resolver su caso el día de hoy
and enter a plea of guilty or no contest,
y declararse culpable o no lo disputo?
I'd sentence him to 5 days in the Broward County Jail with credit for any time he has in.
Y 5 días en la cárcel dándole crédito por el tiempo que ya ha cumplido en la cárcel.
Or he can bond out for $25.
O puede pagar $25 y salir bajo fianza.
Judge, this is a municipal ordinance, so the public.
I understand.
Sí.
I understand.
Sí,
Sir, what would you like to do?
¿Y qué desea hacer? El abogado de la defensa no tiene nada que hacer porque esto es municipal. ¿Qué quiere hacer usted? ¿Quiere pagar la fianza o quiere pasar los días en la cárcel?
La fianza es de $25.
So, is $25 bond?
Yes.
Sí.
Pero yo puedo hacer una llamada.
But can I make a phone call?
Yes.
Sí.
They'll let him make a phone call. I find probable cause bond is $25.
$25 es la fianza, puede hacer la llamada y ya determiné que sí hay indicios de culpa.
Anybody else need a Spanish interpreter?
¿Alguien más?
¿Alguien más? Español. Sí, español. Yep, one more. ¿Qué es tu nombre?
Oh, at North Broward too?
¿Qué? Manuel Paredes. Manuel Paredes.
Spell the last name for me, please.
Paredes, P-A-R-E-D-E-S. Page 21, you said? No, it's Arena. No.
I've been informed, Judge, page 25.
Oh, 25. Okay.
Bottom of page 25, so. Where's the
Paredes, Manuel Alejandro.
file? Cuando termines aquí, tienes que hablar con ese señor. Ok, está bien. Ahora, escuchar, el intérprete va a hablar.
Okay, Mr. Manuel Alejandro Paredes.
Se llama Alejandro Paredes.
You're here this morning on a violation of probation.
Usted está aquí por violar el régimen de prueba.
Judge Gottlieb signed a warrant. He wants to see you. There's no bond on that case.
No hay fianza en ese caso, pero el juez Gottlieb quiere verlo.
No bond.
No se le va a dar fianza.
Anybody else at the main jail?
¿Alguien en la cárcel principal? ¿Alguien más?
No one else here at
Okay, I'm going to go to North Broward and see. I think there's somebody there.
Yes, ma'am. I know you don't have pages, but this guy's on page 20. Last name is Hernandez Felix.
Page 20.
Yes.
Hernández is what I have here. Hernández.
Mr. Hernandez, can you see us?
¿Nos puede ver, señor Hernández? No.
Can you hear us?
¿Nos puede escuchar?
Okay, Mr. Hernandez, you're charged with violation of probation.
Señor Hernández se le acusa de violar su régimen de prueba.
Judge Cholera wants to see you.
El juez Corla lo quiere ver a usted.
There's a warrant with no bond to see Judge Calra. It looks like you have a court date
Parece que usted ya tiene fecha de la corte. Hay un auto de detención.
on June the 6th
Junio 6.
at
Tiene fecha en la corte.
8:30 in the morning. You'll see Judge Calra. I do find probable cause.
A las 8:30 va a ver al juez Corla. Ya yo hallé que sí hay indicios de culpabilidad.
Thank you.
Gracias.
Anybody else there at North Broward?
We have plenty, but not to speak fast.
Okay, thank you, sir. Would you like to call your? Would you? Thank you very much for coming. I appreciate it.
Anytime, Your Honor.
Yes, Judge. How are you today?
Hi. Good morning.
Good morning. John Hager on behalf of Joseph Arena.
What
Judge-
page is he on?
I'm going to look. I'm sorry. Got to check this out.
Page 21, Your Honor.
21. Thank you. Judge, this is also this is a bond that's set that requires a nebia.
Yes.
I've talked with Ms. St. Laurent that I'm going to meet at 10 o'clock. We're asking for the purpose of the nebia that this be reset to your docket later at 1 o'clock. But I'd like to actually argue for a lower bond right now, if possible.
Okay. Well, first of all, I have reviewed the probable cause affidavits and the information that I've been provided. Mr. Arena?
Yes.
Okay. Mr. Arena, can you see us?
Yes.
Okay, Mr. Arena, you're here today for a magistrate hearing. Your attorney is present. Can you see your attorney?
Yes.
Okay, I don't want you to say anything about your case because your attorney's here to speak on your behalf. You want me to reset this to 1 o'clock, or do you want me to make a determination now with regard to probable cause? I don't want to separate a bond argument from the nebia part of it. So if you want to
Okay,
address that this afternoon, then I'll reset it for 1 o'clock.
That would be fine.
We can do it all at 1 o'clock this afternoon.
That would be fine.
Okay.
I appreciate it. Thank you.
I'll reset it to 1 o'clock.
Okay, great.
We'll see you then, Mr. Arena.
Judge, if you want to go back to the punishable by life offense, domestic violence case, I'm prepared to make.
I haven't had a chance to review the
Okay.
reports that he gave me, so I'll take a minute. Terry Shane Sturgeon.
Sturgeon? Sturgeon?
Mr. Sturgeon, you're here charged with aggravated battery with a deadly weapon, also charged with assault, also charged with resisting an officer without violence. You're also charged with harassing a victim or witness and informant in a secondary felony case, and you're also here on a violation of probation or community control in a 2015 case. As to each of the counts, I do find probable cause. On count 5, the violation of probation, you're being held no bond. You have a date to see your judge on that case on June the 8th at 8:30 in the morning. The state wish to be heard as to the other counts.
Judge State would ask for $25,000 bond on count 1. Another $25,000 bond on count 4. The convenience bond on count 3 is okay, and 2.
Can you hear?
Yes.
Okay.
Yes, sir.
I'll hear from you, sir.
Oh, thank you. Judge, speaking of Mr. Sturgeon, unfortunately, at this time, he's unemployed. He's looking for work, but he's had no job prospects. He has no money in the bank, no property. We'd ask you to take that into consideration in determining a reasonable bond on counts 1 and 4.
Okay, I do find probable cause as to each count. As I said, on count 1, I'm going to set bond in the amount of $15,000. On count 2, bond is set at $100. Count 3, $100. And on count 4, set bond in the amount of $5,000. On count 5, there's no bond on the violation of probation. As a condition of any bond, should you be able to post that bond, Mr. Sturgeon, you are to have no contact whatsoever with Yesenia Blanco or Natalie Osorio. You understand?
Yes, ma'am.
No contact, direct or indirect.
Yes, ma'am.
We add her. Natalie Osorio. Robert Heil.
Mr. Heil is approaching, Judge.
Is it Heil?
Maine. How do you pronounce your last name? Heil.
Judge, I received a text. Follows up all with the public defender's office. I received a text message from another attorney with regards to this case. They're not going to represent him, but they provided me information. As you can see, that the victim is his son. They both live at the same address, but it's an address that he owns a place.
Who's he?
Mr. Howe, Mr. Robert Howe. That's his house.
Okay, that's the name of the victim as well.
Right. Believe he's junior.
The third.
Third. So he's been gainfully employed for 25 years. He works at a steel plant, I believe, Judge. I just need to go back and look. He's a plant manager at Certified Metal for 25 years. The victim in the case currently has a case pending with DC. Well, I think the court should know before setting bond.
Just want to make my objection.
Yes.
Your Honor, for release conditions, it's really to determine if Mr. Heil is ensuring his future appearance in court and if he poses any danger to the community. I don't see how the victim's criminal history is relevant to either one of those factors.
Judge, what I'm saying to that is, I believe the court should have a total picture of what's going on. They shouldn't look at we shouldn't look at things in a vacuum. What I can tell you is, I'm giving you background information that is related to the case. Mr. Heil, is currently watching over the victim's kids, his son's kids, because he has a case with DCF. I think the court should know that, should know what was going on at the time. The victim wasn't allowed at that house. So I don't understand how if he's watching the kids and that the custody is with his father, well, what's he doing at the house?
Okay, well, I'll take that into account, that you're telling me that he wasn't supposed to be at the house where this incident occurred. But for purposes of me setting bond on Mr. Heil, I think the state's right, is that what I need to look at is this particular case and whether or not Mr. Heil poses a threat to anybody in our community, and whether or not he will appear, if bond is set, whether he will appear for court.
I completely understand that. I understand that the court has to determine whether or not he's a danger to society and whether or not he will return to court.
So what do you want to tell me about him? How about we do that?
Well, I'll rely on what was informed to me from another attorney is that he's gainfully employed for 25 years. He works for Certified Metal, which I believe is in Broward County. Mr. Romero would have additional information. He was at the main jail, so I didn't get a chance to talk to him in detail.
Okay, so...
and I do have more information, Judge.
Okay.
And adding with what my colleague said, he's 48 years old. He's been living in our community now for about 38 years. He has members of his family that live there. He's married. He's been residing in the same apartment with his wife for 21 years. Judge, the alleged victim is his son, who's 26-year-old. And what is relevant, Judge, is that Mr. Akil actually was the one that contacted the police. I think that's very important, and that goes towards the element of whether or not he's a flight risk. He's the one that actually contacted the authorities involved in this case. Judge, he is a registered voter here in Broward County. I'd ask you to consider what my colleague said, the particular information that I gave you as far as his strong ties to the community, and ask you at this time to consider imposing a bond of $2,500 on Mr. Akil's behalf.
Did pretrial release not interview him because it's a domestic violence case?
No, we interviewed him, Your Honor.
Just don't make a recommendation. Okay.
Correct, Your Honor.
All right.
As to his prior record, he had a prior DUI adjudication in 2010, driving with a license suspended in 2016.
Okay. Does Mr. Heil have any reason to have any contact with his son?
Not at all right now.
Okay.
And like my colleague said, his son at this time isn't living there. He wasn't living there. He went there, and to their surprise, that's why Mr. Hill contacted law enforcement.
Okay. State, did you want to be heard with regard to bond?
Yes, Judge. State would ask for a $10,000 bond.
Okay. I'm gonna find probable cause as to aggravated assault with a deadly weapon, domestic violence. I'm gonna set bond in the amount of $5,000. I'm gonna order as a condition of his bond that he have absolutely no contact with Robert Hale III, indirect or directly, no contact. You understand, sir?
Yes, sir. Yes, ma'am.
Okay.
Judge, the state would also ask that he have no firearms or weapons.
And any weapons that he has, he needs to surrender.
Yes, Judge.
How about Althea Josephs?
Althea Joseph?
She what?
Dismissed.
Dismissed?
Yes.
So she was released?
Yes.
Okay.
At least.
That was a reset from yesterday. Kimberly Radar.
Judge, she's over at the North Broward Jail.
Thank you.
If the court, she would like to resolve her case to a time served if the court is so inclined.
If Ms. Radar would like to enter a plea to this charge, I would give her 5 days in the Broward County Jail with credit for whatever time she has in.
I didn't discuss the.
Ms. Radar, can you hear us?
Yes, I can.
There's an attorney here in the courtroom who's indicated you might like to resolve your case if it was time served, but the offer today, if you want to resolve your case, is adjudication and 5 days in the Broward County Jail with credit for any time you have. I do find probable cause. Your bond is set in the amount of $25.
She's currently homeless right now. It's not a bond she can afford. Will the court consider 3 days in line with the fact the cop, police officer, and the probable cause affidavit went and arrested her and didn't give her a warning? It's not that she was warned prior to the incident.
I understand. My offer is 5 days. If she wants to take it, she can.
It's up to you, ma'am.
I have no choice. Yes.
You do have a choice.
What's that, ma'am?
Your bond is $25. You could
I don't have $25.
you could see the judge who's going to be handling this case, and you could ask for a trial.
No, I'll just stay.
Pardon?
I'll just stay for 5 days.
Okay. Raise your right hand, ma'am. You swear or affirm to tell me the truth?
Yes, ma'am.
You can put your hand down. Just state your full name, please.
Kimberly Rader.
Miss Rader, you understand you're charged with trespassing.
Yes.
You understand what that means?
Yes.
Okay. This is charged as a second-degree misdemeanor, punishable by up to 60 days in the county jail.
Yes.
You understand that?
Yes.
Indicated if you want to enter a plea today of guilty or no contest, I'll adjudicate you guilty and sentence you to 5 days in the county jail with credit for any time you have.
No contest.
Okay, I'll accept your plea of no contest. I'll adjudicate you guilty, sentence you to 5 days in the Broward County Jail, credit for time served.
Okay.
Okay, good luck to you, ma'am. Amber Elaine Ogren.
She's also at the North Broward Jail.
Are you Miss Ogren?
Yes, ma'am.
You're charged with leaving the scene of a crash involving damage to property and driving with a suspended driver's license, second offense. I do find probable cause as to each of those. Your bond is set in the amount of $100 on count one. You understand?
Judge, I did have an opportunity to speak with her. She wanted me to ask the court if the court would consider an ROR. I could give ties to the community if the court wants to hear from.
No, I'm not going to change the bond. It's $100. Your bond's $100, ma'am.
Okay.
Patricia Gonzalez.
North Broward. Judge, will the court sign an order for her to access her debit card, credit cards, or money?
Which
Ms.
one?
Gonzalez.
Miss Gonzalez?
Yes.
Sure.
So she can bond out?
Sure. Miss Gonzalez, you're charged with trespass, failure to leave property upon order by an owner. You understand that?
No, ma'am.
You don't understand? I don't want you to say anything about.
Judge, I did have an opportunity. Ma'am, don't talk about it. There may be a defense that she was staying at the hotel. Some of her stuff was stolen, and there was a dispute with the hotel staff as to that's why that. So I think she has good defenses,
Okay.
but she told me that she does have money in her property, she would self-bond. So I'm just asking the court to sign an order to that effect.
Okay, Ms. Gonzalez, there's an attorney here in the courtroom. He's advising you not to say anything about the facts of your case. So I'm just telling you what you're charged with. You're charged with trespass, failing to leave property upon order by the owner. And I do find probable cause as to that count, and your bond is set in the amount of $25. I'm going to sign an order allowing you to access your property so that you can bond out, okay?
And then I have to come back?
Yes.
And how long do I have, how long is that?
They'll set the case for you. You need to check with the clerk of court once you bond out, okay?
Okay, thank you.
LaTanya Renee Howard. Good morning, Ms. Howard. You're charged with violating your probation on a misdemeanor case. Judge Halal signed a warrant. There's a $500 bond. I do find probable cause. There's a $500 bond on your case. Angela Renaud.
North Broward, Your Honor.
Yes.
Good morning, Ms. Renaud. How are you?
Not too good.
Okay, well, you're here today on a trespassing.
Judge, this is a 948. I believe the fact that she was arrested for a trespass automatically triggered a violation
Looks like it.
pursuant to 948. In light of the nature of the charge, and I believe she's a co-defendant of Miss Radar, that the court sentenced 5 days to the jail. My understanding is on a 948 hold, and she's the allegations being just a trespass, there won't be a requirement for a danger hearing in light of her violation. That's what
Well,
I'm
if she
asking.
enters a plea, she's going to be admitting she violated her probation. So I'm not sure that she wants to do that today.
What I was going to ask the court to do is possibly set a bond on the no bond hold.
I'm not going to disturb the
Just asking.
judge's no bond, on a violation of probation. In this case, it's a 948 hold. Whether they get a warrant, quickly or how long it takes.
My understanding was because it's a 948 hold, I believe the magistrate judge could set a bond on the case.
set a bond, but
as opposed to a judge signing a warrant where the court wouldn't have jurisdiction in setting a bond.
Right, but I'm not going to use my discretion to set a
understand
bond on the violation of probation. You're charged with trespass, ma'am. There's a $25 bond on that. That also triggered what's called a violation of probation hold, that you're being held no bond on that, okay? You'll need to see the judge that put you on probation. I do find probable cause.
So, when I see, I have a, wait to see the judge?
Yes. You can see the other judge that you're on probation with, okay?
So I have to wait for my court date?
Yes.
Okay.
Okay?
All right, thank you.
Good luck. Ashley Rivera. Where's Miss Rivera?
She's here at main judge?
Miss Rivera is charged with possession of cocaine, possession of drug paraphernalia, also charged with violation of community control. Two separate cases, being held no bond on the violations of community control. Has a court date to see the judge on June the 6th at 9 o'clock in the morning. I do find probable cause as to the possession of cocaine and to the possession of paraphernalia. Bond is set in the amount of $1,000 on count one.
Yes, Judge. Yeah, no bond on counts 3 and 4 probation. We'll see you, Judge, June 6th.
I know I have a bond on count one, but no bond on count two.
Carrie Karchenko.
Mr.
Ms. Karchenko is charged with aggravated battery with a deadly weapon, domestic violence. She's here was pursuant to an arrest warrant signed by Judge Bailey. Judge Bailey actually on the warrant to arrest indicated that the defendant is to be held no bond and is to undergo a psychological evaluation before any change in bond status be considered by any court. So I do find probable cause pursuant to Judge Bailey's previous order. I'm going to leave the bond where it is, which is no bond.
Judge, is there any way, I understand Judge Bailey signed an order?
Yes.
This is a bondable offense, and she is entitled to a bond. I understand it's a dangerous crime, but I understand what Judge Bailey said, but can we set this as soon as possible? Because every day she's sitting in custody without a bond in the case under the statute. She's being she's.
If you want me to reset it for 1 o'clock, and you can call Judge Bailey's office and see what's the first available date, I'd be happy
Sure,
to give it that date.
I'll contact his JA.
Okay.
Problem
I mean,
is, this isn't gonna, if I may, Your Honor.
Yes.
This isn't gonna be Judge Bailey's case. He signed the warrant. He was just the duty judge.
Right.
What I would recommend, and I think this would satisfy, and I don't know if the defense would agree, would satisfy the conditions, is the court could order a Baker Act evaluation. And she will, once the evaluation is done, she'll be brought back to the jail. And at that point, I think that would satisfy Judge Bailey's condition, and then the bond can be set.
I have to have some basis to do that.
Well, I think.
And I don't know if you're making that motion, but I don't know. Haven't heard anything from the defense indicating that that's something that I need to order, unless the defense is telling me that there's a court order from Judge Bailey requesting a psychological evaluation before any change in bond status can be considered by any court. So I'm just telling you that's a court order that was entered on this case.
I understand, but then you have an issue with the writ too, because every day that she's being held without a bond in the case is a possible writ.
I understand it's not my order.
No, I understand
Okay.
it's not the court's order, but I'm just I'm
So
just
I'm going to
asking the
set this
court.
for 1 o'clock. We're gonna reconsider it at 1 o'clock. Okay.
Thank you.
Have a seat. You're going to come back in the afternoon.
Geraldine Marie Pearson.
Ms. Pearson, come on up, please.
Ms. Pearson is charged with aggravated battery. I do find probable cause. Anyone have, State, you have a position with regard to bond on this case? Pardon?
I need one moment.
Okay.
Judge, she does have priors, 2012, 2009. They appear to be her driving priors. State would ask for a $15,000 bond considering the facts of the case.
Defense?
Judge, in speaking Ms. Pearson, she's been residing in South Florida her whole life. She is 48 years old. She's on disability. She gets approximately $735 a month. She is a registered voter from what she just informed me. Financially, she has no money and make no property. She lives in Pompano Beach. She's been renting the same apartment for about 9 years now. Her monthly rent is about $620. She has 2 children, ages 12 to 13. The 13-year-old child is autistic, and Ms. Pearson is the one that basically takes care of her child and assumes all his medical necessities. Judge, from what she advised me, she has no sort of financial resources to post herself out. She has no sort of family or friends that have the financial capability of posting any sort of bond. Considering her priors are dated, what we'd be asking you to consider, Judge, is pretrial release, even some most restrictive. We understand this is a second-degree felony, and that's why level 1 would assure the court where Ms. Pearson is at all times should be confined to her premises, and that way she'll be allowed to, in the position to take care of her children.
Did you interview Ms. Pearson?
Checking to see what, yes, Your Honor, so based on that charge, that aggravated battery,
Right.
you would order supervisor, the court ordered that the
Yep. Okay.
Pursuant to Florida statute, because aggravated battery is defined by the legislature as a dangerous offense, she's not eligible for ROR to pretrial. Also, just advising the court, there was a battery arrest in 2009 that was dropped. 2004, she had a grand theft auto and violated probation.
Okay, I do find probable cause as to aggravated battery. I'm going to set bond in the amount of $5,000. If Ms. Pearson is able to post that bond, she is to have no contact whatsoever with Shirley Dolores Bonito, and she is not to enter or go within 500 feet of the Saxon Wall grocery store.
Judge, I understand your ruling from what the state asked, advised the court that you cannot ROR. Would you consider setting a more nominal bond of essentially $100 and then some sort of higher standard form of pretrial?
No, $5,000 bond and the special conditions that I indicated.
Yes, Judge.
Janira LaFrance.
I've been informed she bonded, Judge.
Okay. I do find probable cause. Tiffany DeFrance.
She's at the North Broward Jail.
North Broward, Your Honor.
Mr. France is here on one count of arson, second degree, 2 capias on to felony, where she's being held no bond. She needs to see Judge Porth on those cases.
And Your Honor, if it please the court, I believe count 1, if a bond should be set.
Yes.
I don't know if you have any of the allegations.
I do.
Oh,
I do.
Okay.
I don't have. I couldn't access them. I'm sorry.
Usually what we have, you have, but I guess you're getting more than we're.
Well, I read it in the morning before I come.
Oh, no, I'm just saying the paperwork attached, we weren't given any, of the-
No, I get it other than what's attached.
Unfortunately, I don't get
all right.
Okay. That's why I'm a little late in the morning.
May I just have a moment? I did speak with her in terms of bond. So, in
Okay.
all candor to the court, Judge, there's no bond that, even if the court set a $25 bond on the arson, it's not a bond she can afford. She's currently homeless right now. She's been going to shelters. I have some mental health concerns in speaking with her.
She's already with Judge Porth.
She is, yeah, but
So-
I don't know if it's a drug court case or a
It's mental health
court
yes.
case.
And
So,
the no bond hold is because there was a no show to conditional release status.
Judge, would the court consider what I can proffer to the court is she has no money in the bank, she owns no property, she can't afford to hire counsel. Would the court appoint the public defender's office on count 1?
Are you not?
I believe on counts 2 and 3 we do represent her.
Okay, I'll point you on count 1.
I just want to know all candid court, Judge. If you give me one quick second, I can check to see if
I'll
we
just put it
represent
on
her.
recall for a minute. Don't worry.
Thank you, Judge.
Mr. France, your case on recall. We'll call you in just a minute. Felicia De Jesus Mora.
Judge, she posted bond.
Bond.
This is wait.
Is it posted?
De Jesus. That's what the deputy told me.
You show the bond posted on that?
Deputy Guerra, did she bond out? I thought you said she bonded out. Yeah.
Mr. Jesus Mora charged with bookmaking, 2 counts, and 2 counts of keeping a house for gambling. It looks like someone's posted your bond. I do find probable cause. Is that her?
No, she bonded. That Susan somebody got.
Okay. All right. That's backs. That backs.
Okay, so I do find probable cause on that, and she has bonded. Jennifer Baxt.
Judge, I also have good news too. Even though she's there, I called her mother this morning, and her mother posted her bond.
On Miss Bask?
Yeah, that's
Okay,
what her
Ms.
mom
Bask,
told me.
you're charged with grand theft. Your bond is $1,000. The attorney here in the courtroom is telling me that your mother has posted your bond. I do find probable cause.
Thank you.
Timothy Mejias.
Conti?
Mr. Mejias, how are you?
I'm fine, how you doing?
Good. You're here today charged with a capias on a misdemeanor charge.
Okay.
Looks like this is an ad charge. Don't say anything, please, about your case. There's a petty theft charge. There's a capias for you on that case, and the bond is set in the amount of $1,000. I do find probable cause.
Okay, that's fine.
Okay. Servio Espeletials Verez.
Your Honor, Conti, he's gonna be a med reset.
He's a medical reset?
Yes, ma'am.
Okay. We'll reset that for tomorrow morning at 8:30. It's a medical reset. Jason Narcissi.
He's here, present, Judge.
Mr. Narcissi's here on counts 6, 7, and 8, violation of probation misdemeanor cases. It looks like there's 3 separate cases. He's being held no bond, needs to see Judge Zeller. Judge Zeller has a date scheduled for June the 6th at 1:30 in the afternoon. I do find probable cause. Anthony Garcia.
Mr. Garcia is here, present, Judge. As a friend of the court, he's going to inquire with the court if you could consider resolving this case for time served.
This would be if he wants to enter a plea of guilty or no contest and adjudication in 5 days in the Broward County Jail. I do find probable cause his bond is set in the amount of $25.
Okay. Let the judge know if you want to accept the offer. Yeah, I'll accept it.
Okay, Mr. Garcia, would you raise your right hand, sir? You swear or affirm to tell me the truth?
Yes.
You can put your hand down. Did you state your full legal name?
Anthony Garcia.
Mr. Garcia, you're here today on a trespassing charge. That's a charge is a second-degree misdemeanor punishable by up to 60 days in the Broward County Jail. You understand?
Yes.
In my understanding, you'd like to enter a plea of either guilty or no contest and resolve this case today. Is that what you'd like to do?
No contest. Yeah.
You understand, do you have a right to have a trial on this case and the right to hire an attorney if you'd like?
Yeah.
By entering a plea, you're going to give up those rights. You understand that?
Yes.
Is that what you want to do?
Yes.
Under the influence of any alcohol or drugs here this morning that would affect your ability to understand what you're doing?
No.
Ever been treated for a mental illness?
Yes.
You are currently taking any medication?
No.
You okay? You understand what you're doing here this morning?
Yes.
Okay, you also must understand if you're not a United States citizen, entering into this plea could subject you to deportation under the laws of immigration and naturalization in our country. You understand that? How would you like to plead to trespassing, guilty or no contest?
No contest.
I'll accept your plea. I'll adjudicate you guilty, sentence you to 5 days in the Broward County Jail, and give you credit for time served. Good luck, sir. Henry Richard Buckley.
Mr. Buckley, come on up, please. Judge, this is a municipal ordinance case.
Mr. Buckley's charged with a municipal ordinance violation, a beverage law violation. I do find probable cause. Bond is set in the amount of $25. If you'd like to resolve this case today, Mr. Buckley, the offer from me is adjudication in 5 days in the county jail.
Yes, ma'am.
Is that what you'd like to do?
Yes, ma'am.
Raise your right hand, sir. You swear or affirm to tell me the truth, the whole truth?
I do.
You can put your hand down. Would you state your full legal name?
My name is Henry Richard Buckley.
Mr. Buckley, as I said, you're here today on a municipal ordinance violation, and that charges you with a beverage law violation, basically drinking in public. You understand that?
Yes, ma'am.
You understand that that's a punishable offense by up to 60 days in the Broward County Jail?
Yes, ma'am.
You under the influence of any alcohol or drugs here this morning?
No.
Ever been treated for a mental illness?
At one time, yes, and I'm not taking any medicine for that right now.
Do you understand what you're doing here this morning?
Yes, ma'am, I do.
Okay, you have any questions about entering a plea?
No. I'd
No.
like to plead no contest.
Okay, I'll accept your plea of no contest. I'll adjudicate you guilty, sentence you to 5 days in the Broward County Jail. Give you credit for time served. Good luck, sir.
Thank you.
Ronald Allen Woodrum.
I've been advised he's a medical reset judge.
Okay. Medical reset for tomorrow morning at 8:30. Sean Dante Malone.
Mr. Malone is here present, Judge. As a friend of the court, he's asking if Your Honor would consider resolving this case today.
Mr. Malone, you're charged with petty theft, second degree. First offense, that's a second-degree misdemeanor, punishable by up to 60 days in the county jail. I do find probable cause. Your bond is set in the amount of $25. If you'd like to resolve the case today, it'd be 5 days in the county jail with credit for time served.
Yes.
Could you raise your right hand, sir? You swear or affirm to tell me the truth? You can put your hand down. Would you state your full legal name?
Sean Malone.
Mr. Malone, you're here today, as I said, on a petty theft charge. It's alleged that you stole something from Publix. You understand that?
Yes.
If you would like to enter a plea today, it would be an adjudication and 5 days in the county jail with credit for time served. You understand?
Yes.
You under the influence of any alcohol or drugs here this morning?
No.
Ever been treated for a mental illness? You understand that by entering this plea, if you're not a United States citizen, you could be subjected to deportation under the laws of immigration and naturalization. You understand that?
Yeah.
Knowing that, you still want to enter a plea.
Yeah, no contest.
Okay, I'll accept your plea of no contest. I'll adjudicate you guilty and sentence you to 5 days in the Broward County Jail. Give you credit for time served. Good luck, sir. Antonio Green.
Judge, I've been advised Mr. Antonio Green bonded.
Okay. I do find probable cause as to Antonio Green and note that he bonded. Craig Dean Moen.
Mr. Mullins here approaching judge. He's asking the court if you will consider resolving his case today.
Mr. Moen, you're here on a capias or a warrant issued by Judge Miller for your failure to appear on a case of possession of paraphernalia. Bond is set in the amount of $500. If you'd like to resolve it today, my offer would be credit for time served.
Okay.
Raise your right hand, sir. You swear or affirm to tell me the truth?
Yes, ma'am.
Put your hand down, please. State your full name.
Craig Dean Mullen.
Mr. Moen, as I said, you're here on a capias or a warrant that was issued by Judge Miller for your failing to appear on a case where you're charged with possession of paraphernalia. You understand that?
Yes, ma'am.
And if you'd like to enter a plea of guilty or no contest, I'll accept that plea and adjudicate you guilty and give you credit for time served. Is that what you'd like to do?
Yes, ma'am.
You under the influence of any alcohol or drugs here today?
No, ma'am.
Ever been treated for a mental illness?
No.
You understand by entering this plea you could subject yourself to deportation under the laws of immigration and naturalization if you're not a United States citizen.
I understand. I'm a citizen.
Okay. I just have to tell everyone that. I'm not suggesting that you either are or are not a citizen. I just have to tell everyone that who wants to enter a plea. You understand?
Yeah.
Okay. How would you like to plead? Guilty or no contest?
No contest.
Okay, I'll accept your plea of no contest. I'll adjudicate you guilty and give you credit for time served. Good luck, sir.
Thank you.
You have $293. Sir, you also must pay $293 in court costs. I'm going to give you 6 months to pay that, okay?
What if I can't pay that?
Well, you need to go to the clerk.
No way to pay it.
Need to go to the clerk of court and ask him about how to set up a payment plan, okay? It's required. I can't do anything about it. It's the minimum that the court costs are imposed, $293. Okay? James Russell Daly.
Is Mr. Daly here? Mr. Daly. Mr. Daly's here, present judge.
Mr. Daly's charged with driving under the influence of alcohol or drugs, a second offense. Charged with operating without a valid driver's license, careless driving, leaving the scene of an accident involving damage to property, failure to submit to an accident report, and DUI with damage to property or person of another. State priors on this, please.
I just got a 2017 still pending no valid driver's license causing serious bodily injury or death. A 2014 burglary of conveyance unoccupied.
2000
That
what?
was-
I'm sorry.
A 2014 burglary of conveyance unoccupied. That was dismissed, Judge, in count 2.
Where do you live? I live with a
That's
On the
within Broward, Judge.
On the 2017 case, who's it pending before? I can hear you guys.
Oh, sorry.
I'm getting that information right now. What's the case number? Go back to
17.
Yeah.
351.
He is out on bond before Judge Shear.
Judge Shear?
Yes, Judge.
What's the case number?
17 351 CF10A.
And that's, what is the charge?
It's non-employment information. Operating a motor vehicle without a valid license.
Okay. Mr. Daly?
Yes, Judge.
I do find probable cause as to each count. On count number 1, I'm raising the bond from $1,000 to $5,000. On count 6, raising the bond from $1,000 to $5,000. On case number 17351 CF10A, a case pending with Judge Scheer, I'm revoking his bond on that case. Going to in order that he be held no bond.
Judge, would you consider not revoking it at this time, potentially placing him on pretrial release, some form of supervision on that case that he's out on? Right now, he did advise me he's living in Coral Springs with a roommate. His roommate's the only person that could potentially post his bond, but he doesn't even think that she can afford the standard bonds which were in place. We'd ask you to consider leaving the standard bonds in place and with some form of pretrial release, some form of supervision.
His bond on this case is count 1, 5,000, count 6, 5,000. I'm going to revoke his bond and hold him no bond on the case with Judge Scheer. He can talk to Judge Scheer about that bond.
Yes, Judge.
Warren Darrell Scott. Mr. Scott, you're here today on a misdemeanor capias issued by Judge McHugh. Bond on that warrant is $2,000. I do find probable cause. Okay. Dion Antoine Rivers.
Mr. Rivers is here at Main Judge. He's approaching. He's asking the court if you would consider resolving his case for today for time served.
Because it's a capias, there's not a driving record. Is that right?
Your Honor,
We can pull one, Judge.
Okay. No, because I think it's because it's a capias.
Your Honor.
Yes.
I don't believe he has a driving record created. He does? Oh, okay.
He would have one because he has it operating without a valid license, so they would have created a DL number, whether he has a license or not.
Just now?
I consider resolving his case today if he's willing to raise his right hand and tell me what his true legal name is. You swear or affirm to tell me the truth, Mr. Rivers?
Yes, ma'am.
Put your hand down, please, sir. State your full legal name.
Dion Antoine Rivers.
And your date of birth, sir. Is it 8/1985 in August?
Yes.
Okay. Thank you. Mr. Rivers can see Judge Feld on this case based on his driving record. Okay, I'm not willing to resolve it today. He's got a $250 bond with Judge Feld. I do find probable cause. Marcelo Gordon.
Mr. Gordon, come on up. You see your present card?
Mr. Gordon's charged with battery by a person detained in prison or jail facility. It looks like that's an add charge. Bond is set, I do find probable cause, and bond is set in the amount of $1,000.
Yes, sir.
Patrick Edward Cento.
Conti, Your Honor. Good morning, ma'am.
Good morning, Mr. Cento. You're here. It looks like there's some add charges here today. Count 6, grand theft in the amount more than 300, less than 5,000. Count 7, grand theft, more than 300, less than 5,000. And count 8 looks like there's a capias on a misdemeanor case. I do find probable cause on count 1. Bond is set in the amount of $1,000 on that's count 6. Count 7, bond is set in the amount of $1,000. And in count 8 on the capias misdemeanor, bond is set in the amount of $500.
Thank you.
Everett Washington Slocum.
Your Honor, if I may approach.
Yes. Where is he?
Judge, it's your President may need to find the services of public defender. He has private counsel, Mr. Michael Alexander.
Okay. Mr. Slocum, I don't want you to say anything. You have a private attorney. You're here today on a capias ad charge.
That was signed by the jury foreperson and Judge Jeffrey Cohen, ordering him to held no bond. He was indicted on 2 counts, 1 count of murder that he already had his first appearance on originally, and the charge before the court today, robbery of the firearm.
Okay, I do find, based on the indictment, probable cause on count robbery with a firearm. Count looks like it's listed as count 3 on this capias felony. Pursuant to that finding of probable cause, I do find proof evident, presumption great. Based on the indictment, I'm going to hold Mr. Slocum no bond on this count until further order of another court. Jose Burgos.
Mr. Burgos is approaching Judge here at Maine to find the services of public defender.
Mr. Burgos, you're here today on charged with failing to register or provide information as a career offender. I do find probable cause as to that count. Anybody wish to be heard on bond?
State would ask for a $5,000 bond, Judge.
Defense? Oh, you're not have this public defender's office. Based on the probable cause affidavit and the capias that was issued, not in custody capias, I do find probable cause. Going to set bond in the amount of $5,000. Anthony Jamal Hamilton. Morning, Mr. Hamilton. You're charged with possession of drug paraphernalia, driving on a suspended license, third or subsequent offense, reckless driving, damage to person or property, and failing to submit an accident supplemental report. I do find probable cause on count 2. Bond is set in the amount of $750. Deontay Lenton.
Mr. Linton, come on up.
Mr. Linton is charged with burglary of an unoccupied structure, unarmed, possession of burglary tools with intent to use, and loitering and prowling. I do find probable cause as to each of the counts. Does the state wish to be heard at count 1 as to bond?
Yes, Judge, I need 1 moment. I see that he's only about 18 or 19.
Pardon?
I see that he's only about 18 or 19. I want to
He's
check.
18 according to the booking sheet.
I want to check the juvenile priors. Jermaine, approach side. The 2015 grand theft motor vehicle, aggravated fleeing and eluding, and 3 counts of leaving the scene. There's a 2014 burglary of a conveyance, armed, 2 counts. Burglary of a conveyance, unoccupied. Grand theft firearm, 2 counts. And 3 counts of petty theft. There's a 2014, it looks like that was. Another 2014 burglary of a conveyance and occupied, 3 counts. End of record.
Started working at McDonald's, making $8.10 an hour. He has no money in the bank, no property. He lives with his father in West Park. I'd ask you to take into account, as well as from what you've heard already, to take into account his financial resources.
Okay. I'm going to set bond on count 1 in the amount of $5,000. Count 2, bond is set in the amount of $1,000. Count 3, bond is set in the amount of $25. Going to order as a condition of bond that he have no contact with Jonathan Feld. Stephen Babisi.
Mr. Babisi, come out.
Mr. Babisi's here on a violation of probation. He's being held no bond. I find probable cause. He needs to see Judge Siegel. Judge Siegel has it scheduled for June the 6th at 8:30 in the morning. It looks like Khalil Pass.
Mr. Khalil Pass?
Mr. Pass is here. Looks like Capias on a traffic case, criminal traffic case. Bond is set in the amount of $250. He's also here on 2 Capiases on a one case felony case pending before Judge Scheer. Judge Scheer issued a no bond hold for no show at a calendar call. I do find probable cause. He's going to see Judge Scheer, looks like on June the 2nd. That's today. It says at 2 p.m., but I don't know if that's what's on the paperwork here today, so you might want to check that out.
Oh, I think it says June 12th.
Okay.
I think my paperwork says June 12th.
Okay, you're right, June 12th. 2 o'clock. Bobby Mojica.
Mr. Mojica, come on up, please. Bless you.
Mr. Mojica's here, charged with 1 count of aggravated fleeing with injury or damage, also driving on a suspended driver's license and failure to register a motor vehicle. State have wished to be heard?
State would ask for a $2,500 bond, Judge. I don't believe that there are any priors.
Defense, you wish to be heard on bond? Their state's asking for $2,500. Oh, wait. Sorry?
He was adjudicated on a battery in 2008.
Okay,
He was arrested for a grand theft that was ultimately dropped. a driving with suspended license adjudication in 2008, possession of marijuana. He received a withhold in 2009. 2013, he was arrested for an aggravated assault and an improper exhibition of a dangerous weapon. Ag assault was dropped, and the improper exhibition, he was adjudicated. He was also adjudicated on discharging a firearm in public. 2014, another arrest for domestic violence, battery that was nullified.
Thank you. Wish to be heard on bond?
Yes, Judge. We'd be asking you to consider $2,500 bond. He's been residing in South Florida now for about his whole life, 27 years. He's working. He works for J&R Woodcraft. He's been working with the same company for about 5 years now. Financially has no money in bank, no property. He lives in West Palm Beach. He's been staying at the same place for over a year. His rent is approximately $550 per month. He has a friend that he's hoping that can post his bond. His friend can basically come up with about around $300, which would be hopefully the 10% at around what we were looking for, about $2,500 to $3,000, and that's what the defense would be asking for, Judge.
Okay, I do find probable cause as to each count. I'm going to set bond on count 1 in the amount of $2,500. Bond on count 2 is $100, and bond on count 3 is $25.
Thank you, Director.
Your Honor, can I intervene? Could the public defender call North Broward, please?
Public defender, call North Broward, please.
Thank you.
Thank you. Laverne McMillan.
This is another case where it's a supplemental report has a little bit more deeper information that
Mr. McMillan here on a court-ordered misdemeanor case from Judge McHugh. Also a burglary with an assault or battery and touch strike battery. I'm just going to take a minute to review an additional police report that was provided to me.
Yes, Judge.
probably not. It should be an Odyssey. Yeah. The second report has more detail. That's really
Okay, I do find probable cause as to each count. As to count 2, does the state wish to be heard?
Your Honor, the state is going to be seeking no bond hold on the punishable by life offense based on the original probable cause affidavit and the supplemental report provided, which the elements would satisfy the offense, and it makes specific mention of sworn reports and information provided not only by the alleged victim, but an independent witness that observed the incident.
Defense, do you wish to be heard?
Just briefly, as to the issue of proof evident presumption grade.
Okay, well, let me make my findings first. I make a finding that there is probable cause based on the allegations in the probable cause affidavit and the initial supplemental report that I reviewed. I also make a finding that proof is evident, presumption is great based on that probable cause affidavit as well. And as pursuant to the case law, having made that finding, I will order that he be held on count 2 on a no bond hold until further Arthur hearing could be scheduled with the court that's going to hear his case. Yes.
Judge, in light of the fact that the court finding proof evident presumption grade, being it's a higher standard beyond a reasonable doubt, I would argue that I don't, the court doesn't have the sworn statements before it to tell whether or not the defendant made inconsistent statements or not. I think what was before the court is not enough to establish a standard that's that is higher than beyond a reasonable doubt.
Okay, the record will note your objection to my findings, and on count 3, touch strike battery, I'm going to set a bond in the amount of $5,000.
Judge, may we recall Mr. France? That was the case that the arson case, North Broward.
Right.
She is represented on the other 2 cases before Judge Borth by the Public Defender's Office.
Let me get to North Broward. Mr. France, good morning almost. Good morning. Okay, so we're back here. You're charged with 1 count of arson, 2nd degree. It's a 2nd degree felony. Also, there's 2 capiases or warrants issued by Judge Porth that have no bonds on them. Yes.
Judge, with regards to bond, there's not a bond she can afford. I was asking if the court would appoint the Public Defender's Office to represent her on the arson case.
I will appoint the Public Defender's Office to represent her on that case. Does the state have any argument with regard to bond?
Judge, the state would ask for a $15,000 bond on count 1. Should she post a bond that she be placed on a GPS monitor for the state, for the well-being of her family?
Judge, she's being held no bond right now. I think Judge Borth would be better at deciding what her release conditions on a monitor or not.
On count 1, arson, I'm going to find probable cause, set bond in the amount of $20,000. If she is released on that case, on that arson count, she will be required to be supervised by pretrial release. With a GPS monitor, I'll waive the $5 per day cost. Pardon me?
Is she permitted to work if she is employed?
If she's employed, she's permitted to go to work. And she's permitted to meet any appointments with her attorney. She's to have no contact whatsoever with the victim of the alleged arson.
That's the person that's
Don't say anything. Don't say anything, ma'am. You have an attorney here. Do you have that name in a?
This victim is Arthur DeFrance. That's what I gave
You have his name written down?
One moment. Taking this from the warrant. Just to be safe, I'm just pulling the information, Your Honor. According to the information, it's Arthur DeFrance, A-R-T-H-U-R. Last name spelled the same way as Mr. France.
Okay, so Mr. DeFrance appointed the Public Defender's Office to represent you on this arson. You need to see Judge Porth on the other cases. I set bond in the amount of $20,000 on that arson count. Joseph Leonel Ceballos.
Mr. Sabalos, dear President, Judge Maine.
Mr. Ceballos is charged with driving with a suspended license, 3rd or subsequent offense. I do find probable cause. Bond is set in the amount of $750.
Yes, sir.
Randy Benjamin Gibson.
Mr. Gibson? Come on up.
Mr. Gibson is charged with possession of a controlled substance without a prescription, another count of possession of controlled substance without a prescription, and delivery of Schedule 1A, 5D drug within 1,000 feet of a church or school. I do find probable cause as to each count. Either side wish to be heard with regard to bond?
Judges, to count 1, the state would ask for a $10,000 bond. He has a 2016 unlawful use of false name. a 2015 possession of heroin, possession of alprazolam, a 2011 delivery of cannabis, 2000 resisting without violence. Judge, those are the Broward priors.
Judge, speaking to Mr. Gibson, he advised he's 46 years old, he's not working, no money to make, no property. Unfortunately, he's homeless. Therefore, there's financially indigent.
Okay, bond is set on count 1 in the amount of $1,000. On count 2, $1,000. On count 3, bond is set in the amount of $7,500. I do find probable cause. Hakeem Alvin Lewin. Mr. Lewin's charged with grand theft, more than $300, less than $5,000. I do find probable cause. Bond is set in the amount of $1,000.
Judge,
Yes,
this was a theft from a person. The state would ask no victim contact.
right. Sorry. Mr. Lewin. If you are able to post bond in this case, you are to have absolutely no contact, direct or indirect, with Nitza Mendez. You understand? Yes or no?
Yes.
Okay.
Good luck, sir.
Eduardo De Leon.
Sierra Maine?
Mr. De Leon is charged with violation of probation on a felony case, being held no bond on that case. He's got his court date to see the judge on June the 7th at 8:30 in the morning. I do find probable cause. Austin Henry.
Mr. Henry, come on up.
Mr. Henry, yes.
I apologize. On count
Who are you talking about? Mr. Henry?
Austin Henry, yeah.
Okay.
For technical purposes, I believe count 2 should be a resist without violence, not obstructing. Him running away from the cops is more resisting. He's not obstructing them doing their search or executing their warrant. But they're not requiring a bond.
They were serving a search warrant.
Right. He ran.
Right. So the statute that they charged him under is
It's 933.15. I have it up here.
right.
Whoever shall knowingly and willfully obstruct, resist, or oppose any officer or a person aiding such officer in serving or attempting to serve or execute any search warrant, or shall assault, beat, wound any person or officer or his deputies or assistants, knowing him or her to be such an officer or person so authorized, shall be guilty of a misdemeanor of the first degree. So the fact that he's running, he's not opposing. They were able to do what they had to do.
It's the exact same language that they use in the resisting without statute.
I
Right?
would have to go
It is-
back to the resisting without.
Look at this. Look at the language they use in the resisting without statute. Is the exact same language that they're alleging there.
Your Honor, because of the language, it says upon executing, so at this point in time, for all I know, they already executed the search warrant, and if they executed the search warrant, point being is, Your Honor, I have no objection, the court finds no PC on count 2. I believe there's PC on count 1, and he already has a no bond VOP hold on 4.
Okay. So on count 1, I'll find probable cause. Bond is set in the amount of $100. On count 2, I'll find no probable cause as to that charge. On count 3, violation of probation or community control, he's being held no bond. And on count 4, violation of probation is being held no bond. Timothy Lewis.
Mr. Lewis, come on up, please. Sierra Maine?
Mr. Lewis is charged with robbery by sudden snatching without a firearm or weapon. He's also charged with petty theft, first-degree property. He's also being held on a court order from Judge Bristol, who's indicated no bond until she sees him on that case. Wish to be heard on count 1, robbery by sudden snatching without a firearm. State.
Judge State would ask for a $10,000 bond on count 1 because he's out on the same offense. Judge also,
Pardon me?
he also has juvenile priors, Judge.
And you said he's out on the same offense?
Count 3 is the same offense for what, the new offense?
Yes.
The juvenile offense. This was a direct file. You sure that's not the same case?
To check, Your Honor.
This is a juvenile probable cause affidavit. Alleging that this happened, looks like
It is possible. So.
27th of November.
If it is the same case, I apologize.
Okay. Okay, so this case, count 1, robbery by sudden snatching is a juvenile case that was direct filed.
It's had a similar offense, though. As a
Okay.
juvenile.
And do you wish to be heard as to bond?
Yes, Judge. And speaking of Mr. Lewis, he's 18 years old. He's been residing here in Southport his whole life. He is going to school. He goes to William Rogers High School. He lives in Fort Lauderdale with his mother.
Bless you.
Mother is the only person that could potentially post his bond. Unfortunately, she's on disability, so limited financial resources. Judge, I'd ask you to take that into consideration determining a reasonable bond on count 1.
Separate cases. He does have a pending separate.
Juvenile.
Yeah, I checked the case number. They're different.
Well, once they direct file, they all come.
Well, all I can tell you is, you see the case number on count 3?
Yes.
I saw what this case number was originally given on count 1. There are 2 completely different case numbers.
Right, but I don't know that that's a.
Your Honor, with 2 different offense dates.
Oh, I see.
There's one, the one before you has a November 27th offense date. Count 3 has a offense date of October 10th, 2016.
I see. Okay, so Judge Bristol has issued a no bond capias on the case number that's listed, which is the juvenile case number 4207, and or directing that he be held until he sees Judge Bristol. Yes.
Nothing, Judge.
Okay, because he was scheduled for disposition on that case with Judge Bristol, and it was a no-show for disposition. On count 1, I find probable cause. I'm going to set bond in the amount of $7,500. On count 2, $100 bond, and count 3 needs to see Judge Bristol. Rodney Estelholm.
Mr. Esselholm is here present, Judge.
Mr. Estelholm is charged with possession of a weapon or ammunition by a convicted felon.
And, Your Honor, if I may, just before the court makes a finding, I spoke with Detective Bates, who authored the probable cause affidavit. His count 2 essentially is an enhancement for armed trafficking, which is a PBL, but, Your Honor, we are not seeking a no bond hold. I don't believe there is probable cause for count 2. As an officer of the court, Detective Bates informed me the gun that was located was not in Mr. Estelholm's actual possession. And my understanding, I've spoken with Assistant State Attorney John Gallagher about this, that in order to charge someone with armed trafficking, the firearm has to be in the person's actual possession.
Okay. So it looks like on count. Okay, so let's just go through the counts first. These are the allegations. Count 1, possession of a weapon or ammunition by a convicted felon.
Judge,
Count 2, wait, let me just get through these, please. Count 3, commission of a first-degree felony with a weapon. Count 3, trafficking in cocaine, it looks like 28 grams or less, 28 grams or more, but less than 200. Trafficking in heroin, 4 grams but less than 14 grams. Possession with intent to sell or manufacture, deliver cannabis. Possession of MDMA. Possession of cannabis over 20 grams. And drug paraphernalia, manufacture or deliver. I'll hear from you.
In regards to the possession of weapon or ammo by convicted felon, it says in the probable cause, and it's a very short probable cause affidavit, the premises that were to be searched, the living room. I don't have a layout of the living room. I don't know where specifically the firearms were located. We know that based on what was heard earlier, that the firearm wasn't found to be on the defendant's possession. I believe there was a case earlier where the person, while they were executing the search warrant, I believe this would be the same house where the guy started running, so there may be an issue of whether or not there were other people residing at the residence. I think you need a little bit more in order to establish, even if they're going the constructive possession route, to establish where exactly the firearm was and where was Mr. Esterholm in relation to where the firearm was found. Was it found in a closed door? Was it found in somebody else's room? I mean, we just need more facts, and I don't think that's enough to charge him with this offense. I don't know who else lives there. I don't know the layout of the living room.
Okay, I heard you. State?
I think there's enough for probable cause purposes. He is a resident there, as it's mentioned. That's his listed address with Palm Beach County as part of his active case that he's a GPS monitor. They found documents pertaining to him, Your Honor, based on the amount of drugs found. And, Your Honor, and the reason I mentioned it wasn't in his actual possession is because for armed trafficking, that is a requirement by statute that it has to be in his actual possession. For possession of a firearm or ammunition by a convicted felon, it is not required that it be in his
I understand.
possession.
I understand. So for count 1, I do find probable cause. On count 1, I'm going to set bond in the amount of $5,000.
Oh, Your Honor, just something I want to bring to the court's attention. Mr. Estelholm, in addition to the Palm Beach case that he is out on, and that is those charges are armed burglary, robbery with a firearm, aggravated assault with a firearm, and felon in possession of a firearm or ammunition. Mr. Estelholm is currently out on bond in Broward County for possession of firearm by a convicted felon.
What case is that?
17340 CF10A. He also has 2012 fleeing and eluding. He was sentenced to 120 months state prison as a habitual offender. Delivery of oxycodone in 2011, same sentence. 2005 possession of firearm by convicted felon and aggravated fleeing and eluding. VOP 120 months. There's other priors, but those are the most significant.
On case number 17340 CF10A, what judge is that pending with?
Judge Lynch.
Okay. Do you wish to be heard with regard to bond? Who's arguing, you or him?
I just argued probable cause.
Okay.
Judge, as far as the monetary amount for the bonds, he's 31 years old. He's currently looking for work. He has something which he does on the side. He washes cars. He gets about approximately $10 per vehicle that he washes. He does have family that reside in our community. He's hoping his mother can help. However, his mother works for a housekeeping department, so therefore her financial resources are very limited. I'd ask you to take into consideration my colleague's argument as far as I know you found probable cause, but the weakness of the case, my understanding is that there are other people that reside in the residence. It's going to be a very, very weak constructive possession case. At the end of the day, I do not believe that charge is going to be filed. I'd ask you to take that into consideration determining a reasonable bond.
Okay, so I do find probable cause as to count 1. I set bond in the amount of $5,000. As to count 2, I find no probable cause. As to count 3, I do find probable cause. Bond is set in the amount of $15,000. As to count 4, I do find probable cause. Bond is set in the amount of $75,000. As count 5, I do find probable cause. Bond is set in the amount of $1,000. On count 6, I do find probable cause. Bond is set in the amount of $1,000. Count 7, I do find probable cause. Bond in the amount of $1,000. Count 8, I do find probable cause. Bond in the amount of $1,000. As to case number 17340, CF 10A, possession of a firearm by a convicted felon pending with Judge Lynch, I do find, based on this probable cause, pursuant to the Florida statute, that I am going to revoke his bond on that case. He'll be held no bond until he sees Judge Lynch on that case, if the state will prepare an order on that.
Yes, Your Honor.
Charles Parks. Mr. Parks is charged with possession of cocaine, possession of cannabis 20 grams or less. I do find probable cause. Does anybody wish to be heard on bond? Bond is set in the amount of $1,000.
Yes, Judge. State would ask for a $2,000 bond. Judge, he does have 3 cases pending in front of Judge Rothschild.
Right now?
Yes, Judge.
And what are those cases?
172797 CF10A, dealing in stolen property. 17255 CF10A, dealing in stolen property again, false ownership information pawn item, dealing in stolen property, burglary via conveyance. 172465 CF10A, burglary of a conveyance and occupied. Judge, he's got also a prior possession of cannabis, prior fleeing and eluding, possession of prior 2004 possession of cocaine. The fleeing and eluding was in 2010.
Do you want to be heard as to bond?
No, your Judge, we're fine with the standard bond.
Okay, but as to case number 172797 CF10A, case number 172555 CF10A, and case number 172465 CF10A, do you want to be heard as to the revoking those bonds on those counts, those cases?
I'd ask you to defer for the assigned division judge to handle those matters, Judge. They can certainly put a motion forward if they're moving to revoke the bond. I don't think they're moving to do that at this point, so I would ask you to defer to the division.
I'm going to, on case number 172797 CF10A, revoke his bond based on the probable cause affidavit in this case. On case number 172555 CF10A, going to revoke his bond in that case based on the probable cause affidavit in this case. In case number 172465 CF10A, I'm going to revoke his bond on that case as well. You can see Judge Rothschild regarding those matters. Stephen Acosta.
Mr. Acosta, come on up.
Mr. Acosta's here on a violation of parole. Looks like that has been confirmed. I do find probable cause. He'll need to see someone on the parole violation. Bedson Pithome.
Mr. Petitone? Petitone.
Mr. Petitome, charged with driving on a suspended driver's license, also charged with a violation of community control and a violation of probation. He's being held no bond on the violation of probation and the violation of community control. On the driving on a suspended license, I do find probable cause. There's $100 bond. Maurice Miller.
Mr. Miller? Maurice Miller?
Mr. Petitome has a court date on June the 6th at 9:45. Mr. Miller there?
Mr. Miller, come on up.
Mr. Miller's here on a violation of parole. I do say that has been confirmed. Mr. Miller will need to see the parole board regarding that violation. Vincent James Pizzella.
Mr.
Mr. Pizzella?
Mr. Pizzella is charged with possession of cocaine and disobeying a stop sign. I do find probable cause. Anybody wish to be heard?
Yes, Judge. He has a 2015 possession of cannabis, driving with license suspended that he was given time served on. 2010 trespass is on probation. Probation was revoked and he was given time served.
Okay, on this possession of cocaine, I do find probable cause. His bond is set in the amount of $1,000. Alexander John Roussos.
He's here present, Judge? Yes.
Mr. Roussos is here on a felony capias, also on a violation of probation felony, being held no bond on each of those. It was a no bond issued by Judge Scheer when it was apparently a no-show on a violation of probation status. He's scheduled for June the 7th at 8:45. I do find probable cause.
We'll be senior Judge June 7th, 5 days from now.
Sidney Marley, ATN.
Etienne?
Mr. Etienne is charged with violating his probation in a 2015 case. There's a no bond warrant signed by Judge Singal. He has a court date for June the 8th at 8:30 in the morning. I do find probable cause. Joshua Tharp. Mr. Tharp is charged with disorderly conduct, breach of the peace, also charged with violation of community control. And on two separate cases, there's a no bond hold on the violations. On the disorderly conduct, there's a $25 bond. Mr. Tharp will be seeing his judge on June the 6th at 8:30 in the morning. I do find probable cause. Ashton Humes. Is this Mr. Humes?
Main Judge?
Yes, Mr. Humes.
Hello?
Charged with touch, strike, battery, domestic violence. Also charged with a warrant for violating his pretrial release on a felony case signed by Judge Bailey. There's no bond on Judge Bailey's case. On the touch, strike, or domestic violence, anyone wish to be heard?
Yes, Judge. Judge State would ask for if bond were to be posted, if he was given a bond on count 2 for no victim contact, Judge.
Okay. Defense?
Judge, he's 20 years old. The alleged victim is his father. Therefore, there's nobody that's going to be able to post his bond. He's not working. No money in the bank, no property. Oh.
Okay, well, he needs to see Judge Bailey on the other case. On this case, I do find probable cause. Set bond in the amount of $2,500. If he is able to make that bond, he is to have no contact whatsoever with Michael Humes. You understand that, sir? You understand? You understand you're not, if you're able to post bond and get out of jail, you're not to have any contact with Michael Humes?
Yes, Your Honor.
Okay.
Yes, Your Honor.
Philip Michael Valchin, Jr.
Mr. Dawson?
Mr. Valson's charged with grand theft, more than 300, less than 5,000, a fraudulent attempted use of an ID of another person without their consent. It's also here on a violation of probation or community control. There's a no bond on the violation. As to count 1, bond is set in the amount of $1,000. Count 2, bond is set in the amount of $1,000. I do find probable cause as to each count.
Yes, Judge.
Judge,
yes?
State would ask for no victim contact.
Mr. Valson,
They're going to order. Hold on 1 second.
if you are able to post bond in this case, you are to have no contact with Eaton Carroll or the Fun Center of Fort Lauderdale. You understand?
Yes, ma'am.
Okay. Christopher De Lomas.
I've been advised Mr. Delamo is bonded.
Okay. Francisco Palanco.
I've been advised Mr. Polanco bonded.
I do find probable cause. Juan Pablo Beltran.
He's here at Maine.
Mr. Beltran is charged with violation of probation on a 2013 case, violation of probation on a 2012 case, and violation of probation on another 2013 case. There's a no bond hold signed by Judge Merrigan. You'll see Judge Merrigan on June the 7th at 8:45. I do find probable cause.
Okay, I got a lawyer, John Week. Okay, I got a lawyer.
He has private counsel, John Wicks.
Okay. Ramor Montfort Octave.
Mr. Octave, come on up.
Mr. Octave is charged with aggravated assault with a deadly weapon without intent to kill and carrying a concealed firearm. Anybody wish to be heard?
Yes, Judge. Judge, he's got a case pending. A delivery of cocaine and delivery of heroin, 2016. Another 2016 delivery of heroin at or near Park, 2016 valid.
Let her know all the felony drug.
Is there one pending now?
Yes, Judge.
Okay, I need a case number and who it's with, please.
Case number is 16-5731 CF10A, the delivery of cocaine, delivery of heroin, and 16.
That case, Your Honor, is before Judge Rothschild.
Attorney?
Showing public defender.
Okay.
The second case is 16-5815 CF10A.
And obviously that's also before Judge Rothschild, being represented by public defender.
Okay. You wish to be heard?
Judge, I'd ask you to not take any action on those cases. I'd ask you to address the matter that's here before you. We'd be asking you to set a reasonable bond. He's been here for over 12 plus years. At this time, he's currently looking for employment. He was working for a warehouse. He was only making $10 an hour. He lives in Pompano with his brother. We'd ask you to set a reasonable bond in the amount of $2,500 on count one, $1,000 count two, and the other two cases, I'd ask for the court to address those cases.
Okay, on count one, I do find probable cause on that case. I do set bond in the amount of $5,000 on count one. Count two, bond is set in the amount of $1,000. As to case number 165731 CF10A, I'm going to revoke his bond based on the probable cause affidavit in this case. And on case number 165815 CF10A, I'm going to revoke his bond on that case as well. You can see Judge Rothschild regarding those cases. Stephen Bowens.
He's here present, Judge Amain.
Mr. Bowens is charged with possession of cocaine. I do find probable cause. Anybody wish to be heard?
No, Judge.
Bond set in the amount of $1,000.
Good luck, sir.
John Guillemay.
Mr. Guillemay. Deputy Johnson, Mr. Guillemay on page 30, the bottom. It's an ROR, Judge. He's been released.
Okay, so he's been released. I do find probable cause.
so the last person here at Maine is, I believe, a gentleman we still have recalled. That was at the beginning of the document, Mr. Stephane Beasley.
Okay.
I don't know if we can address this case now.
Are you prepared to address it?
I read the supplemental reports.
Let me just look and see if I had read these. Okay, is this Mr. Beasley?
That is correct, Judge.
Okay. Mr. Beasley,
Yes, ma'am.
you're here on one count of touch strike battery, domestic violence. One count of violating an injunction against repeat sexual dating violence. Count 3, burglary with an assault or battery. 4, missile into a dwelling, vehicle, building, or aircraft. Domestic battery by strangulation, dating relationship. Count 6, criminal mischief, more than $200. Burglary with assault or battery. Count 7, and burglary with an assault or battery. Count 8. With regard to probable cause, does anyone want to be heard?
Judge, I don't have an argument as to probable cause.
Okay. I have reviewed the reports, and as to each of the cases, I do find probable cause, each of the counts. Does anybody have an argument as to bond?
Your Honor, state as far as 3, 7, and 8, the state would be seeking no bond holds. With regards to the other offenses, the only, as the court's aware, on all the cases 1 through 9, they all involve the same alleged victim. I just want to advise the court, count 10 also involves the same alleged victim, her property. I can proffer, I pulled the original report. A neighbor saw claims to see Mr. Beasley go to the victim's home, damage her door, essentially pull the door handle off the door. And when Mr. Beasley sees him, he tells him, if you call the police, I'm going to burn this place down.
That's on count what?
The criminal mischief, before Judge Poll on count 10.
Count 10, okay.
Judge, my just brief argument.
Okay.
I know one of the counts is a punishable by life offense. I would argue what's
Actually, 3 of the counts.
the 3 of the counts.
Right.
I would argue that what's presented before the court doesn't rise to the level of proof evident presumption grade, which is higher than beyond a reasonable doubt.
Okay. So as to count 1, having found probable cause, I'll set bond in the amount of $1,500. As to count 1. As to count 2, violation of an injunction, set bond in the amount of $5,000. On count 3, count 7, and count 8, I do find probable cause. I also find that the proof is evident and the presumption is great. Based on my finding on the probable cause affidavit and my finding that proof is evident and presumption is great, I am going to order that he be held no bond on count 3, on count 7, and count 8. On count 4, throwing a missile into a vehicle, I do find probable cause, set bond in the amount of $3,500. In count 5, domestic battery by strangulation, I do find probable cause, set bond in the amount of $5,000. Criminal mischief, $200 or less. Count 6, I set bond in the amount of $1,500. And in count 9, touch, strike, battery, domestic violence, finding probable cause, I do set bond in the amount of $1,500. And on count 10, there's a capias issued where bond is set in the amount of $500.
Yes, Judge.
I also order as a condition of any bonds, should he make any bond or post any bond in the future, that he have absolutely no contact whatsoever in any way with the alleged victim in this case. Phone calls, text messages, direct or indirect. You understand that, sir?
You understand? No comment?
Okay. Oh, yeah, yes, on the other page. Thank you.
Judge, what time do you want us here in the afternoon?
Wait, I have a couple more.
Then we-
I have Mario Leon Elizondo, North Broward. We have Mr. Elizondo. Can you hear us? I can't hear you. Thank you. Okay. Mr. Elizondo is charged with touch or strike battery, domestic violence. I do find probable cause. Does anyone wish to be heard?
Judge, may I ask him some questions? He was a gentleman in transport from the main jail to North Broward. I didn't get a chance to talk to him.
Okay.
Michelle,
Can you talk to him in private or not?
I could call him. I could speak to him in private. I just didn't know he was there.
Okay.
In the meantime, I have Zwick. Come on. You gotta get the phone over here.
I have Daniel Patrick Zwick.
Yes, ma'am.
Mr. Zwick, you're here today on a violation of probation on a felony case. You need to see Judge Merrigan. Judge Merrigan has issued a no bond hold for your arrest. I do find probable cause.
Okay, can I throw a few things in there for you?
No, nothing to be said today. You'll see Judge Merrigan.
What date is it, do you know?
Nope. You ready? Okay. If we could have Mr. Elizondo again.
Judge, I'm going to ask for the court to allow the public defender to take photographs of his injuries.
Okay.
He said he had a scrape.
I'll sign an order authorizing that. Does Mr. Elizondo, you're charged with touch or strike battery domestic violence. I do find probable cause as to that charge. Does the state wish to be heard?
Judge, I'm not seeing any priors in the state of Florida. I don't know if pretrial has anything.
Judge, I could tell you that he is gainfully employed. He says he DJs nightclubs here in Fort Lauderdale, Miami area. Makes about $500 a week. The issue is that he can afford right now. He helps pay some bills. He has about $100 or $200 in the bank. He has difficulty accessing it because the money that he would rely on bonding out is at the victim's house. I believe it's his mother. I would ask the court, in light of the fact that the court has no priors, the court set a $1,500 bond.
Has anyone had any contact with his mother?
I do see priors, but they are all from the
They're what, juvenile? No contact with his mother?
No, Judge.
Okay. Is that where he lives?
That's where he lives, Judge.
I'm going to set bond in the amount of $2,500. I'm going to order that you have no contact whatsoever, directly or indirectly, with your mother, Dina Ruth Menendez. You understand?
Yeah, but $2,500 I can't afford.
Okay. Well, that is.
This is my first offense, ma'am.
I understand. Bond is $2,500, and you're ordered as a condition of that bond to have no contact whatsoever, directly or indirectly, with your mother. You understand?
I understand.
Okay.
Judge, can I just say something to him?
And I'm
Sir,
signing an
the
order.
$2,500 bond, if you go through a bondsman, normally you pay 10% of that. So 10% of $2,500 is $250.
So how do I go through a bond? How do I?
They have bondsman's numbers at the jail. You can contact one.
Okay.
All right.
They come and bail me out.
No, you need to talk to them about arranging payment and how to bond out. But I'd rather not say anything else because we're being streamed online.
Yeah, we're on